Hi, Warriors. This is Jalen, my legal warrior, and today we have Kristen Roberts. Hi, Kristen.
Hi.
Can you go ahead and introduce your firm and how you're associated with your firm and how long you've been in practice?
Sure. My name's Kristen Roberts. I am the founder and managing attorney of Trestle Law, APC. We are a full service intellectual property firm. We help businesses build a bridge from their brands to their bank accounts. I have owned my firm for almost 6 years now, and I've been in practice for about a decade.
Thank you so much for joining us.
Yeah.
So, one of my first questions that comes to mind is, have you seen any changes in operations with the USPTO during COVID-19?
Yeah, so it's interesting because the United States Patent and Trademark Office is it is a government agency for the most part, and it is it's administrative in nature. And they've always really done things online. So in terms of their operations, they're no longer letting people go into their office. They're no longer, I think they're having their people work remotely. But in terms of filings and things like that, we haven't seen a lot of interruptions. They have, however, extended a deadline. So extended all the deadlines for both patents and trademarks. So anything that was due between, I believe, it was March 27th and it was like end of April, they extended to June 1st. But they also, by extension, I mean they extended it all the way out, those deadlines that occurred to June 1st. They're now giving you 30 days from those dates to get things on file. So it's pretty much everything that you can think of: responses to office actions, priority dates, priority dates, meaning international applications, asking for extensions of protection, things like that. Certain patent filings, certain response deadlines, et cetera, et cetera. So that has actually been helpful because a lot of my clients, or a lot of clients that have pending things that are experiencing interruptions in their businesses, can't necessarily afford to engage counsel to help them respond to, let's say, an office action, or pay an additional fee or anything like that. And so they're really kind of, originally they were left going, well, what do? We aren't getting extensions. So this extension happened like towards the end of March, I want to say. And it was a little bit scary before that. They were going, well, what do? I mean, we've got these deadlines. How do we take care of this? So now there is a clear guideline in place from the USPTO. It's on their website, uspto.gov. It's right at the top banner. You can click on it and read all of that stuff. And then also from on the patent side of things, there have also been some changes, some new resources for inventors. There is a new program that they just came out with, and it's basically a patent program where they allow you to put your new like invention or your new patent on a website that the USPTO has put out. And you can basically, it helps match inventors and their patents with people that are trying to license their inventions. So it's almost like a marketplace where you can kind of say, hey, here, this is my new patent. And you can search as a licensee, or as a potential licensee. You can search for different patents that are coming up available to be licensed. So that's been helpful. And then they're also doing a fast track examination process, not on the trademark side, but on the patent side of things. For small micro businesses, they're basically waiving fees, which is really exciting. There's a few other things that go into it, but that's kind of the basics.
Okay. Wow. Yeah. Sounds like there is definitely a lot of accommodations that are, going on.
Yeah. And they've been trying to roll out a lot of these programs for a while, but I think this was kind of the kick in the butt that they needed to start rolling out some of these initiatives. So these kinds of things were always sort of in the works, but now they have an even stronger reason to want to do it.
Okay. Fantastic. Would you say that there's been an increase in filings from businesses during COVID-19?
I think that I've seen an increase in, at least on my side of the business, because it's hard to tell with the USPTO side. There isn't like a database that I can go to like find out how many new filings, today that they filed. But I mean, I'm sure I could search the USPTO website on tests, but it's not really set up to say like on this date we've had this many filings. But on my side of things, for my clients, I've definitely seen an uptick in wanting to protect their intellectual property and wanting to pursue trademark filings. So I could only assume that that will translate into an uptick in filings. Yeah.
Okay. Why do you think that individuals currently now are more interested in doing that protection, having that protection?
Well, especially now as we're shifting to online, exclusively operating online, away from brick and mortars, more and more people and companies and small businesses are starting to realize the value of their brands, especially as they reach these wider audiences. And it also lends itself to more instances of infringement, confusion issues, things like that. So I really think that it's sort of more of a proactive response, trying to avoid being reactive with your intellectual property, knowing what's out there, knowing who's doing what, and wanting to protect it. And then also, I'm seeing a lot more innovation happening, right? So people are coming out with courses, people are coming out, they're launching all of this really cool material and they're building brands off of this stuff. And so they want those brands to be protected because they know, especially if you operate online, you know how easy it is to just lift something from somebody else. And having that legitimacy, having that protection of a trademark registration can really help. And then last, I don't know if you heard this, but the Supreme Court just ruled on a case recently that had to do with trademarks. And it was about whether or not they basically helped resolve a split in the circuits, where some circuits would say, well, it is, if you file a trademark infringement suit, you need to show willful infringement. They were leaning more heavily on whether the infringement was willful in order to get damages. And other circuits were saying, well, actually, we disagree with that. We think that as long as you can show there was damage, as long as there's damages to be had, willful infringement isn't necessarily as important as long as the infringement was taking place. And the Supreme Court helped resolve that split and basically agreed with the second reasoning, which was, we don't necessarily need you to show willful infringement in order to be entitled to collect damages. And by damages, I mean like disgorgement of profits and things like that. Attorney's fees are a different issue, and those are still relatively hard to get in a trademark infringement suit. But I predict an uptick in trademark infringement litigation, because now getting those damages, attaching those damages for disgorgement, treble damages, things like that, it's not necessarily going to be as difficult to prove those up because there's no longer this split in the circuits.
Yeah. Earlier you had mentioned that, there's a international, trademark, and, with this uprise of individuals that are now wanting to protect their intellectual property. If somebody, let's say out in Dubai, has the same idea as somebody out in California and they both, apply, how would that get resolved? Because it is, a free market on the internet.
Sure. So there isn't an international trademark. So there's no international trademark registration system. There are a number of treaties that certain countries subscribe to, the primary one being the Madrid Protocol. The Madrid Protocol is a treaty that countries subscribe to, and if they accept those protocols, then you can actually file with the USPTO and use your American application as a basis in other countries to form. It's basically, you're asking for an extension of protection. So you're saying, hey, other countries that are also a treaty to what the United States is a treaty to, I want to file my trademark in these other countries, but you can actually do it through the United States Patent and Trademark Office. So I, as an American attorney licensed to practice before the USPTO, I can help American companies file their applications in other countries through our system, but it's through it's administered through WIPO, the WIPO, World Intellectual Property Organization. And so, but you use the application system that's set up on the USPTO's website. So it really depends. The example you gave, let's say in Dubai, it really depends on whether or not Dubai is a party to the treaty, the Madrid Protocol, and is one of the countries that we can ask for an extension of protection when we go to file that application. Certain countries, like for example, believe it or not, Canada, only just recently became a party to the Madrid Protocol. So if in the past you wanted to have a trademark in Canada, you actually had to file directly in country. So you had to find a Canadian attorney, you had to do, do all of that. And so that's why we have, organizations like INTA that help connect other attorneys, international attorneys with attorneys here in the United States, so that you can have that network of international attorneys that can help you if something were to arise. Also, if you're filing here in the United States for an extension of protection in another country, and something happens during the examination process in that other country and they issue an office action, I would be precluded from practicing in that country because I'm not able to say, okay, now we just have to do these things in Spain because I'm not a Spanish speaking attorney. I'm not a Spanish attorney. So you still have to go find local counsel to help you resolve any issues that arise during the examination process. But it's a great way of getting that going because you can tick off multiple countries at once in the same application.
Got it. And you said this was the Madrid Treaty?
Madrid Protocol, yeah.
Madrid Protocol, okay. Mm-hmm. And so if a country is not part of that protocol, then it sounds like
you go in country, yeah. So you file in country. And likewise, the reverse is true as well. So let's say there are other countries out there and they want an extension of protection here in the United States. What they do is they actually file their application here in the US, but they file under a different basis. So rather than a 1A or a 1B, it would be like a 44D or a 44E. There's different sections of the Trademark Act that allow them to protect their marks through our system.
I do have one more question.
Yes.
So why should a viewer use an attorney versus one of those self-help services that one can find online?
Yeah, so it really just depends on your comfort level of trademarks, right? So if you understand what likelihood of confusion is, if you understand whether or not your mark is strong, because there's a spectrum of strength, right? So there are strong marks and weak marks. And if you're comfortable understanding how the examining attorney that's going to get assigned to your application will evaluate the strength of your mark, how a examining attorney conducts a clearance search through tests, how, whether or not you understand the difference between, a mark being identical and a mark being likely to be confused with another mark. If you're comfortable with that stuff, then sure, using a self-help kind of system will work, but they don't ask you those questions. They don't ask you things like, what is your mark? What's the intent of your mark? How do you plan on growing into your business? What's the goal of this mark in the future? How do you plan on making money off of it? How do you plan on putting it to work for you? Because I said earlier that what we do is we help our clients build a bridge from their brands to their bank accounts. And the brand encompasses more than just a trademark, right? I mean, your brand is sort of the magic sauce that makes your business what your business is. And your brand can be personal in nature too, right? Like you're Jalen, and that's a brand in and of itself, but then you also have My Legal Warrior, which is a brand in and of itself. So do you have a strategy in place for not only protecting it in terms of registration, but then actually implementing a strategic way of bringing yourself additional income and revenue through licensing, through brand partnerships? And if you don't, then it's a little bit short-sighted to say, well, I'm just going to go to, a company that can just file this mark for me, because ultimately you might just be spending money that you are going to waste. And so having an attorney can help you really understand what the landscape looks like and what the risks are of using the mark that you're using, and having somebody really kind of there to hold your hand. Also, the application process isn't really that easy. There's, you have to figure out what classes of goods and services apply to you. And then also there are ways to get creative. If there are other marks out there that are confusingly similar, you can sometimes get creative with things like design marks, using different class descriptions to avoid a potential likelihood of confusion refusal. And those analyses just aren't done in those types of companies because they're volume business, right? So they are get as many in as we can, file. You send your information to them and they file it for you. They're not sending you a draft application saying, okay, does this look right? Is this kind of the effect that you want? Is this the feel that you want for the description? There's none of that. And so that's kind of what a lawyer gets you, is they get you the expertise, and they also get you the consulting that you need to understand how you can then put your brand to work for you once you do get that registration certificate. My biggest piece of advice to those people is before you pay the money to the do-it-yourself service, do some research. The USPTO's website, uspto.gov, has an enormous amount of resources because you do not have to be a lawyer to file a trademark. There is no legal requirement that you're an attorney to file a trademark. And so if you're, just hell bent on, doing it yourself and filing it yourself, because there are those people out there, they're just not going to end up being my clients, right away, which is fine. I do have some that I call, I call them LegalZoom refugees because they come to me after going through a company, a do-it-yourself company, and it gets botched, and now they're facing an office action and they don't know what to do with it, and they are not really sure how to handle it. And oftentimes we go back to the drawing board and just refile because there were things that we could have done differently in the application. So it does almost wind up being like a waste of money because they spent it on this do-it-yourself, and then they wind up coming to me anyway and then spending what they, twice as much because they're, we're having to kind of undo the ball of twine that already got wrapped up. So, if you're one of those people that really wants to do it yourself, great, awesome, but just make sure you understand what it is that you're doing yourself, because if you don't, you're going to run into issues and then you're going to need a lawyer to help you fix them. And then it could often cost more money than it would have just to have them do it for you the first time.
I remember on their website, there was a box for, would you like an attorney appointed to you? Are you aware of that?
Yeah, so you can do that. It costs more money though. My recommendation is if you want the lawyer, right? If you want the lawyer and you want the full service experience, you might as well interview attorneys, right? There's nothing, do a Google search, find some, it doesn't need to be me, right? But most lawyers do no cost consultations. I'm one of them. I don't charge for a consultation. If you're interested in a trademark, you get a free 30 minutes to kind of ask me what I think about your trademark. And oftentimes I'll say, I don't really like that mark, right? Because if you're a grocery store and you're calling yourself groceries, I'm going to be like, there's no way you're going to get that trademark, right? But we can start to brainstorm ideas for that grocery mark. Maybe you do a design mark, right? Maybe you include like an O in the word groceries in a way that's really cool. So yeah, you have to disclaim the word, but the mark is really, really unique. And you can really kind of promote that as your primary branding. So I think there's always going to be a benefit and there's always going to be a need for attorneys, even though there are still these programs out there and these, inexpensive ways of getting something on file. I just think if you're going to do that, you might as well just read up on how to do it and figure it out and do it yourself. But
yeah, no, of course. Yeah. And I like that you gave that example as like the grocery example. I think that's actually very valuable because it is something very simple, but yet having like your expertise kind of figure out, okay, well, actually, this is probably a better way of going about it. And more likely than not, your trademark is going to be accepted because you get what you wanted, and then you also kind of add in that design.
Right. And then we can also do things like, when certain issues come up, for example, if a mark is cited as descriptive, usually what the examining attorney will do is give you an option to amend it to the supplemental register. But the supplemental register so it's still a trademark. You can still, sue for infringement. You can, put the R with the circle, all of that. But the problem is that it's reserved for marks that otherwise wouldn't be allowed to be registered on the principal register. Namely, those marks are descriptive in nature. And so in those office actions, it pays to be really strategic in how you respond because everything is public record. So if you agree to amend to the supplemental register, you are admitting that your mark is descriptive. Mm-hmm. So there are ways kind of to reserve some of those arguments that, hey, I don't believe this mark is descriptive. You're telling me it is. And so I'm just acquiescing to what you're asking for. So there's a way to put stuff together. There's a certain way to word things that a lot of people don't know without practicing.
Yeah. Completely agree. Well, thank you so much for your time and top-notch information and knowledge and expertise. And if clients or our viewership wanted to get a hold of you in some way, how could they do that? What's the best way?
So it would be either through my website, TrestleLaw.com, TrestleLaw.com, or they can email my assistant. Email Cami. Her email is Cami, C-A-M-I, @TrestleLaw.com. Just reference that you heard about us through your video, and we'll set up a no-cost consultation for you. And if you decide to move forward with us, you'll get that 10% discount.
Awesome. Thank you so much again for your time, the discount for the viewerships, and just, being an awesome attorney, a kick-ass attorney out here in San Diego and California and the USPTO.
Yep, likewise. All right, well, have a great rest of your day, and I'll talk with you soon.
Sounds good. Thank you.
All right, thank you. Bye.